I'm honored to welcome you to the inaugural United Nations Public Lecture. Each month, the UN Family in India will be sponsoring a public lecture on a key issue relating to India's development and its role in the world. We are especially honored that our first public lecture marks the 14th International Day for the Elimination of Violence Against Women. Helping to end violence against women is the topmost priority for the United Nations in India. We all know that violence against women is everywhere a problem. It is a grim but wholly unshakable fact that this terrible problem happens in just about every country in every part of the world. In India, the situation facing women is alarming. The UN Secretary General, Mr. Ban Ki-moon, has called upon all of the countries in the world to be part of the Unite campaign to end violence against women. The aim of this campaign, which is supported by the UN Family in India, is to work with partners to end domestic violence, end human trafficking, end violence in public spaces, end violence against children, and end gender-biased sex selection. Today, around the world, countries are observing this International Day. The United Nations hopes that on this day, all countries and all of us recommit to do everything possible to end violence against women.
As far as I'm concerned, I would pose the question whether our laws have become more gender just. Has access to justice increased or improved qualitatively and quantitatively? These are some of the questions that I'll try and answer. Now, two recent events that have occurred in the space of less than 2 weeks. One has been the sexual harassment of a vulnerable intern working in the Supreme Court of India, and the other of a journalist in Goa amidst an event which supposedly brings together the brightest minds in the country. Now, the common link between both these cases is that the two accused men were in a position of authority in relation to the complainants, and the women were in a subordinate work relationship with them. This is common between the two cases. One of an intern who disclosed in her blog that she was sexually harassed by a Supreme Court judge, and the other of a journalist who reported whatever she had to report to her employer. We notice a failure of institutional responses in both cases. Neither the Supreme Court of India nor Telka reported what clearly constituted cognizable offenses to the police. All I can observe is that laws are implemented in discriminatory and selective manners. This happens when you deal with Dalits, when you deal with tribal women, when we deal with people belonging to minority communities, when you deal with situations of communal and sectarian violence. Then, of course, when it comes to armed forces, we find both impunity and immunity in operation. They cannot be sued for offenses without the prior sanction of the government. In my opinion, a historic opportunity was lost for the implementation of the UN Security Council resolution that rape is not a weapon of war, which, quote, reiterated the necessity for all states and non-state parties to fully comply with the obligation under applicable international law, including the prohibitions of all forms of sexual violence, close quote. I now finally come to the issue of attrition. The law, if not implemented effectively, leads to attrition. Broadly speaking, attrition refers to the processes whereby cases simply do not enter the criminal justice system or drop out of the criminal justice system. At one of a number of points of exit from the system, such points can exist and be located either in the procedures or in the processes or in the sheer absence thereof. This is the bias located in the substantive, procedural, and methodological tools of the law, which is the institutional bias of the justice delivery system. This bias lies in disbelief of the woman abused. It lies in the way the victim is being asked to revisit the entire gruesome experience again and again, in the obscene questions that are being put to her in cross-examination, and in the fact that she is made to repeatedly reiterate the statements on several occasions. It lies in the kind of evidence that is collected from the victim, the manner in which she is being made to go through a medical examination, the manner in which the veracity of her evidence is required to be confirmed. And here we know what happened to the victim of the Shakti Mills case. She was asked to actually view the pornographic videos to confirm that she had been shown the same videos when raped. Now, this bias plays itself out in the entire medico-legal examination which is conducted. It plays itself out in the two-finger test. It plays itself out in introducing proof of character. It also slips into the methodological tool itself when the protocols developed by the state public health departments requires height and weight of the survivor to be filled up for determining signs of resistance. Whether or not the law considers resistance or absence thereof as a relevant factor, which it doesn't, for determining the commission of an offense. Thus, the intertwining of the bias, the procedural requirements, and the methodological tools lends to a situation where the abused person is first disbelieved, then is made to recount the gruesome incident again and again, and then exposed to various methods of evidence collection in court procedures, compounding the crime by several folds and creating potential points of attrition. Any sexual intercourse or sexual encounter between people in the age group, even if it be consensual, makes them statutory rapists. There is, of course, one exception to this rule, and that is if you happen to be married to someone below 18 but above 15, there is no rape. Marital rape is not an offense under the Act in the name of preserving family values. Death penalty was introduced as the panacea for all the problems that I have indicated above. In the case of the young intern, the backlash has already come. I know of a few judges who have requested the Chief Justice of their respective high courts to remove all female staff from their offices and to not provide any women interns. One can imagine several other variations of this backlash of a more deadly nature, removing women from public spaces. The 2,000 crore Nirbhay fund remains unutilized, whereas it could have been used to facilitate access to justice in many different ways. Police accountability and an accountability of the armed forces eludes us to this day. What is needed is accountability to civil society, not just to the state alone. And impunity in different forms continue to be the norm. Prosecution and conviction are the exception to the rule. The rates of judicial attrition continue to be high, ranging for the reasons that the criminal justice system is not victim-friendly and focuses on the rights of the accused alone. Lastly, of course, it follows from what I've said, institutional sexism in the practice and processes of the criminal justice system needs to be dismantled. This alone will ensure gender justice. Thank you.
You will join us each month as the UN continues its lecture series throughout the rest of the year. And I would especially like to give a round of applause to the young people that are with us today. You are our future. Thank you very much.